Welcome once again to my channel. My name is Msiment Alex, and basically today I have come to take you through foundations of land law. Basically, we want to look at what we call compulsory land acquisition in Uganda. What is required for one to, how can someone compulsorily take someone's land in Uganda? This basically applies to government. How does the government acquire land? That is what we mean compulsory acquisition of land in Uganda. Basically, I want first take you to the principal law, the grand norm of Uganda. That is none other than the Constitution of the Republic of Uganda. Basically, under Article 26 of the Constitution of the Republic of Uganda, which basically provides that every person has the right to own property, either as an individual or in association with others. What does that one mean? It means that you can either be individually, whether land can either be individually owned or it can be owned in association with others. When you look at clause 2 of that article, it tells you that no person can be deprived of the right to own property. You have to appreciate this, that no person can be deprived of the right to own property. That means whether or not you must exercise, you must enjoy the right to own property. But when you go to paragraph B, and actually paragraph B, it brings out exceptions under which someone can compulsorily take the land of the other person. Basically, this basically comes in when the government wants to take on land for public benefit. For public benefit. How can we appreciate this? You need to appreciate that under paragraph A and B of Article 26, basically clause 2, it tells you that no person shall take the land of another person except if that compulsory acquisition or that taking into possession is done within the premises of the law, within the compromise of the law, that you cannot take land of another person except, number one, if the compulsory acquisition or the compulsory taking on is done within the lines of the law. For example, you must provide what we call the adequate compensation. That is very important that you need to appreciate. You must provide the adequate compensation. Adequate compensation, what do we mean? If it is the land of, let's say, 50 million, then you will not take the land of 50 million, then you compensate someone with just like 10 million. That means that amount of money is not adequate. Or anything that you provide in return, like in the payment of that land, then it must be at least of equal value to that property. That's what we mean by adequate amount, adequate compensation, basically. So as we move on, you need to know that another rule under compulsory acquisition is that when you're taking possession of land, of someone's property, you must, the compensation must be given prior to taking into possession. You cannot, let's say you cannot take into possession, then later you give compensation. That is totally wrong, and it is actually prohibited by the law. It is totally wrong and prohibited by the law. That is very important that you need to appreciate. Number one is that the compensation must be adequate. And number two is that the compensation must be paid prior to taking into possession. What do we mean by prior taking into possession? That means the taking into possession, rather the compensation must be given before you take on the property of the other person. You need to first give that person compensation. That is what we mean, basically what is provided for under Article 26, clause 2. That before you take into possession of someone's land, you must give him adequate possession. That is important. I will interest you in the case of Amot Godfrey Nyakana versus Nema and others. It's a constitutional petition number 3 of 2005. It's a Supreme Court decision. In that case, the Supreme Court of Uganda observed the fact that it actually upheld the principle provided for under Article 26 Clause 2, that you can't take into possession of someone's land before you pay adequate compensation. That is very important, that you must appreciate right from the beginning. Godfrey Nyakana Amot versus National Environment Management Authority and others. It's a Supreme Court decision, Constitutional Petition number 3 of 2005. Please appreciate that decision. It will actually guide you on what you need to know. That the entire doctrine, the entire principle of compulsory acquisition was actually discussed by under what we call the Food and Agriculture Organization of the United Nations. It was in Rome in 2008. They actually defined compulsory acquisition to mean the power of the government, to acquire private rights in land without willing consent of its owner, not of its occupant, in order to benefit the general public. That is what we basically mean. That when you read that paper, it was actually titled The Compulsory Acquisition of Land and Compensation. It was written by the Food and Agriculture Organization of the United Nations that sat in Rome in 2008. That compulsory acquisition basically means that taking into possession of someone's rights in the land without his consent for the benefit of the general public. Here we mean, for example, if the government says we want to take on Nakawa, a specific part of land in Nakawa, let's say to build the airport. Let's say they want to take on a specific part of land in Namugongo, let's say, that they want to build a hospital that will benefit the general public. The government then has to follow that procedure laid down under Article 26 to take on the possession of that land. Of course, you must always know that with reference to Article 237, the government does not have land. That is that is some other thing that you need to always appreciate. That the government does not own land. Government can only own land through the compulsory acquisition. That is important. Because when you read Article 237, it will tell you that the land in Uganda belongs to the citizens of Uganda. And therefore, if the government wants to acquire land pursuant to clause 2 of Article 237, then it is through compulsory acquisition. Of course, compulsory acquisition must be in conformity with Article 26 of the Constitution. That is very, very important. You need to also go and look at it's also another paper titled An Explanatory Note on Issues Relevant to Public and Private Partnerships. It also describes what amounts to compulsory acquisition. That is very, very important. Of course, I wish to remind you that land acquisition, or what we call compulsory acquisition, is also governed by the Act of Parliament, basically known as the Land Acquisition Act. The Land Acquisition Act lays down all the procedures that must be followed throughout the entire process. All the process that must be emphasized, that must be exercised, that must be taken into account while doing what we call the compulsory acquisition of land in Uganda. It is known as the Land Acquisition Act. I must always emphasize that you must take into consideration of Article 26, Clause 1 and Clause 2. Clause 1 gives rights to all individuals, all citizens of Uganda to own property. Clause 2 says that no person shall deprive of another the rights, interest, benefit, in any property of any description, except if that compulsory acquisition and taking into possession is done through the laid down procedures under the law. And number one is giving the adequate compensation, and number two is giving the compensation prior to taking into possession. We have the leading case. The leading decision on land acquisition is the case of National Roads Authority, Uganda National Roads Authority versus Irumba and another. That is the leading case. It's a case of 2015 Ugandan Supreme Court decision. It's actually a Supreme Court case of number 2020, actually a case of number 22 of 2015. Please appreciate that is decision of Uganda National Roads Authority versus Ilumba and another. That case will actually tell you that the land acquisition is actually it admits, the Supreme Court admitted that yes, Article 26 is subject to limitations. They brought that principle that they related the two articles, that Article 26 is not absolute, is actually not a non-derogable right. It can be deprived. An individual can be deprived of that right. That is very important. That's so. The government, yes, it does not own property. Pursuant to Article 237, land in Uganda belongs to the people. But at a certain point, for public interest, for the benefit of the general public, then the government can acquire property through the compulsory acquisition. That is important. UNRA versus Irumba and another, the case of 2015. They defined what amounts to public interest. Read that case. They brought out clearly, they discussed what amounts to adequate compensation. They brought out what exactly it means when we say that that compensation must be given prior to taking into possession. That is very, very important, that you must, as you grow into the principles of land law, as you grow into the foundations of land law, that you need to appreciate. To that effect, of course, you need to also look at the decision of Justice Stephen Mobiru in the case of Okonye Merod Nyero versus Okuna Jackson and another. It's a case of, it's actually a civil appeal number 60 of 2017. Read about that, read on that decision of Justice Stephen Mobiru. Justice Stephen Mobiru is actually known of giving very nice principles, bringing out the best principles. Please appreciate that decision. It will actually also give you, it will actually shed light on compulsory acquisition. I want now basically to look at what do we mean when we say that compensation. I earlier talked about it, that compensation must be fair and adequate. To that effect, of course, you must look at the case of Shema Cooperative Ranching Society, Shema Ranching Cooperative Society versus actually it's Shema Ranching Society and 31 others versus Attorney General. It's a case of 2013. 2013. Read that case. It discusses basically what amounts to comparison to paying fair and adequate compensation. The recent decision to that effect, you have to read the case of Simiyu, the case of Simiyu versus Uganda National Roads Authority. It's a civil suit number 18 of 2021. The decision was given in 2024. Actually, the decision was given on 21st of June 2024 by Justice Faruk Rubega at the High Court of Mbale, wherein he held that the failure to compensate the landowners during the compulsory acquisition renders the acquisition, that failure to compensate the landowners during the land acquisition during the process of compulsory acquisition renders the acquisition null and void. Appreciate that decision of Justice Rubega Faluk in the case of Simiyu versus Uganda National Roads Authority. So what are basically remedies upon failure to, when you breach the law provided for under Article 26? What are basically the remedies? Number one, of course, you sue for damages and recovery of the land. You sue for recovery and damages if it so happens that there is a breach of that principle. Of course, to that effect, appreciate the case of Nyakana, appreciate the case of Rubega Faruku, the decision of Rubega Faruku in the case of Simiyu versus UNRA, a case of 2021. Otherwise, I want to thank you so much for being on my channel. I always encourage you to subscribe, share with friends. Please comment, ask questions, ask for clarifications. Where you feel you need clarifications, please, I'm always ready to provide. Thank you. Thank you so much. Bye-bye.